Oh,
Like,
hello, everybody. I
here.
do apologize for not responding. Who are we talking about? Life Jacket Lips?
Yes.
Oh, fuck her.
If you didn't see the first 40 minutes of my stream, I called out, well, I didn't call out. I reacted to a video or part of a video by Matt Walsh from the Daily Wire. He has 3.34 million subscribers and decided to run his mouth comparing Somali daycare fraud in Minnesota with VA disability fraud.
Oh, really? Oh, fucking.
And I had only seen men on YouTube react to it, so I decided to very kindly tell him my thoughts.
Should invite him in and then just rip him limb from limb.
Squid things. I got 0 Fs to give, 0 Fs to give. I don't even give an F if yeah.
Yes. Now, here's the thing. What I would say, I think that like what's going on in the state, and I know what you're going to say. Yeah, well, fucking people owe you money. It's beside the point. Here's the thing. I think that people need to go and fucking, I don't know, get a life, because there's way too much shit going on now in this country, in the world.
I have to go real quick. So you entertain people for a minute.
Absolutely. Ladies and gentlemen, boys and girls, we are at war. No, I'm joking. What we do? Oh god! Oh my god! That woman, Leslie, fucking flamingos. Fucking, you can tell I've only just woke up because I'm literally using one eye to read that document. Hi everybody. If I haven't said hello to you, then I don't know. To be honest with you, I don't even know why we're talking about that absolute freaking accident excuse of a fucking human. I mean, like, every time you want to get your way, you sue people if you want to get your way. But when you don't get your way, you go and play the victim and the label thrown and the, oh, feel sorry for me. My brain's not, bollocks. Yeah. And then we got fucking some fucking journalists talking shit. And then we got a president who wants Greenland. You know what? He did exactly the same fucking thing that Putin did. Prick. 60 plus years of NATO, 60 plus years of allies. You had to fight. Don't even get me going. No, Kesha. No, not the best of Leslie ran down a dad's leg. Best part of Leslie Ferderigos went splattered against the wall when her mother decided to fart. Yeah, but anyway, so
and thank you for being patient with me. We have taken a turn in the 3-year-old not using diapers anymore. However, with that being said, it requires a lot more hands-on work
and washing
and cleaning out a container of stuff. So, it takes time and a little bit more time away. So I appreciate the patience with me.
Why should I put a sock in my hole? I am the best when I'm half asleep. I'm like a fucking train wreck with razor blades.
All right. One thing before we get into this, thank you for dealing with the fact that I didn't stream yesterday. I know we've been talking about doing the Tyler Robinson stuff for days. However, yesterday I had a meeting with someone for a corrective exercise intro session. And I also, with talking to them and doing that session, wanted to redo the link tree to make it more user-friendly for people booking sessions and just clicking links. So I hope that is all, plus their programming and helping them is going to take up a significant part of my time and focus, considering we are working on one-on-one together. So we are Baby Squid has graduated to her own blue bucket. It's more like a green potty chair, but yeah.
Before you start, can I tell you a joke?
Yes.
When my daughter was created and she was birthed, I was on exercise. I come back from exercise, and obviously I went, yeah, I'll change nappy. Let the mother have a break. So I go there, I lay her on the table. She's giggling, I'm laughing, I'm still half into my gear. And as soon as I open that nappy, I think chemical. I think she could be used for chemical warfare. So what do? I go and get my respirator, and I don my respirator on.
Dude,
I take the filter off, but I put my respirator on and I start changing the nappy and everything. And it did look like if a bomb exploded, there was powder dust everywhere and all that shit. And then when I finished, she was giggling. I went to take my respirator off, and then she started crying. So I put my respirator back on. And then she stopped, and I went to take it back off again. And she started to cry again. And I went, "You cheeky cow. Are you freaking not even 6 months old?" And she was calling daddy ugly. I swear to God, that was funny as fuck.
And now you understand why Spawn is never on camera.
Mm-hmm. Wait, what? Cheeky fuck.
All right. So getting into this motion, since we've been at this for almost an hour. The Florida Bar's motion to dismiss the Second Amended Complaint because the last two streams were her original complaint and her Second Amended Complaint, which were only filed 8 days apart. She filed in 8 days 3 different complaints, more and more trauma dumping each one, which is why we don't trauma dump in legal filings, because when you file court cases, and someone actually did send me the video where she had said this now, when you file court cases just to get shit on the public record, your dirty laundry becomes public record. And when you make people angry, well, yes, you abuse the system, but when you make certain people angry because you accuse them of crimes, which is a crime, which is called defamation. If she had been ballsy enough to mention my name, but she just mentioned everything that I said in my stream, basically telling everybody that who she was talking about, which without actually mentioning my name, because the girl doesn't have the guts to actually mention people by name when it comes to her defamation claims. But after her, we have all of her husband's lawsuits too, because he wanted to sit there and co-sign her calling people felons for reading publicly available documents. So not only are we doing Leslie's skeletons, but we are also exposing Michael's too. Because, he wanted to sit there and co-sign her calling people felons for reading publicly available documents. If you don't want people knowing your dirty laundry, don't sue people and put your dirty laundry into the public record, especially when you live in Orange County, Florida. And Orange County is the easiest county in the entire country to obtain documents, because Tiffany Moore Russell has to be the best county clerk or the best court clerk in the entire country with her website.
And on the technicality, I was thinking about this yesterday when I was streaming. On the technicality, all this, every single case that she's used and every video that she's done, everything can be actually used against her as evidence to show pattern of behavior, pattern of I forgot the other word. So you got pattern of behavior, and then there's something else. Because if you think about it, it's like she uses and abuses the system to silence people or to control people's actions and what they say. So on a ding ding. And the divorce, how many times now? Twice, wasn't it? 2 times, yeah? 3 times. So 3 times. Oh, okay. Yeah, I think I've just. Okay, carry on.
However, she tried to intimidate the wrong person.
Or people.
I don't intimidate easily. Somebody tried to intimidate me yesterday in somebody else's stream. I had posted links, well, not links, but I had posted screenshots in your Discord about like a certain subscriber. Well, apparently they had posted like, I better watch out or something like that. I'm like, and somebody was worried about me and messaged me, and I was like, I have half of a give a shit and enough supply to render half of South Georgia inoperable, we're good.
Yeah, and I got a response for that because I know exactly who you're talking about and what you're talking about and everything. Here's a bit of advice. Don't come onto my fucking neighbor and shit on my doorstep because you will not fucking enjoy the fucking response. And trust me, I will not give quarter, and I definitely won't stop until I find my resolve.
But thanks for the view. But
Yes,
if
yes.
a certain someone's gonna have like 18 alt accounts and try to troll me, thanks for the view, and yeah, good luck.
Gee, I mean, yeah,
and thanks for the one gifted Squid Pro quote membership. I appreciate you.
Yeah, but listen. At the end of the day, okay, until they've actually overstepped that line, right? You can de-arm the minefields. You can de-arm the auto targeting systems. I've got many of them, and I've already did my research. And I'll chat to you later.
Yep. But here we go. Hey, really late. How is everyone? Well, we're just getting into the document, but if you want to see me go on a rant on something not related to anything What the Hales, and go off on a creator with 3.34 million subscribers, watch the first 35 to 40 minutes of the stream. Anyway, this is their response and their motion to dismiss her second amended complaint. So, yeah. So everybody's familiar with this 12b6. The Florida Bar, pursuant to Federal Rules of Civil Procedure 12b1 and 12b6. Say 12b6 one more time. Hereby moves this court for entry of an order dismissing the second amended complaint and states as follows.
What do you mean 12b6?
Freaking
yeah, I just said it.
Bubble brain.
Yeah, you said it. Say it one more time, so I did. Sorry. You get.
Plaintiff asked this federal court to provide injunctive and declaratory relief concerning ongoing attorney disciplinary proceedings pending in the Florida Supreme Court, the rules regulating the Florida Bar, promulgated by the Florida Supreme Court. The Florida Bar is an arm of the Florida Supreme Court, specifically authorized to file and prosecute complaints in attorney disciplinary proceedings pursuant to the rules regulating the Florida Bar. The Florida Bar was served with the first amended complaint February 13th. The court subsequently granted plaintiff's motion for leave to file a second amended complaint. The Florida Bar's response is therefore directed to the second amended complaint. Plaintiff's claims should be dismissed pursuant to an 11th Amendment immunity, absolute immunity, and the Younger abstention doctrine. For a variety of other reasons, the complaint should also be dismissed because plaintiff has failed to state a claim on which relief can be granted. Put simply, the United States District Courts cannot regulate the practice of law in Florida as plaintiff requests. Oh. I mean, and they're so far, like, so basically, in the first paragraph, they basically shut down her entire argument. I mean, the first paragraph, they shut down her entire argument. Like, it doesn't matter what she said in 38 pages of BS. This court does not have the jurisdiction to regulate the practice of law in Florida. Am I wrong on that? Like, and they bring up three things: the 11th Amendment immunity, absolute immunity, and Younger abstention, which I don't know what that one is. But they brought up three things. And they said they basically said pick your reason. But they basically say this isn't about whether she feels wronged. It's about whether the court can even see this because it's not their jurisdiction. Right?
Mm-hmm.
Like in the first freaking paragraph, the U.S. courts cannot regulate the practice of law in Florida as plaintiff requests. Plaintiff alleges and claims for relief. Attorney disciplinary proceedings are pending against plaintiff in Florida Supreme Court cases. The cases are currently before a referee appointed by the Florida Supreme Court. The complaint reflects plaintiff's disagreement with these proceedings and states she believes she will not receive impartiality under the procedures set forth in Chapter 3 of the rules regulating the Florida bar. In particular, plaintiff alleges Chapter 3 is unconstitutional due to the use of a local bar investigative committees, which she contends are inconsistent with the recommendations of a 1992 report by the ABA. She alleges that she has been harmed by the use of such committees. I'm just
It sounds to me that like every single case has a similar sort of argument from her side of or point of view. It's always the same thing. It's like, you know, I'm being wrongly treated, blah blah blah, and I feel like a victim. Treat me like a victim. I want my money. I need my bitty. You know,
I want my mommy, but I sued her, so she can't help me. You need to.
Yeah, and the fact that she now brings us the ADA rules. Oh no, she hasn't. Has she done it yet? No, she hasn't.
They haven't addressed it. I don't know if they even will, because so far in this, like, I haven't read this whole thing, but so far in this, they are only addressing the procedural shit. Like, hey, you can't even see this, so why are we arguing anything else?
Mm-hmm.
Also, for them to even talk about this, like, she could, in my view, she is the type of person who would use, if the Florida bar in their motion to dismiss brought up anything as related to her mental health, she would weaponize that against them. So for me, I am not a lawyer, never claimed to be one, never tried to be one. However, if I were to just argue this as like you and I were arguing it, or I was talking to a lawyer and he asked me how I would argue it if I were him, I would not bring up anything related to her mental health for the sole purpose of she would weaponize it, because that is what she does.
But you could on a technicality, due to behavioral issues, ask for a court enforced psychological evaluation, which I've read it up. You can actually request that, and it's not based on your mental health. It's based on your behavior.
Well, Sharon, I will be keeping up with her current cases as well, to see what happens with those, especially the ones where they are, like, Jeremy had filed a motion to get her labeled as a vexatious litigant. Because if that goes through, she can't sue anybody without getting permission from a judge. So,
well, congratulations to the members there.
And here and after, thanks for the 5 gifted Squid Pro Quo memberships. We are doing there is a post on the community page that is open for everybody, but it is going over any cases that we are covering, active cases, anything Hales or not Hales, any cases that I've touched on this channel, what you guys think, give your opinions, and then we will be having a members only on the 31st, which is a Saturday. And that will be a members only where we will discuss your thoughts, because this is at the end of the day a community, and see which comments aged like milk and which ones aged like a fine wine and deserve a chef's kiss. So that is our members only, and that'll be going on every month. That'll be just one of our members only things. So
I'm glad I've got some influence on people.
Hey, Hill on top. Oh, let us hope what she has done to her mom and dad is deplorable. Yeah, I know I don't get along with my mom and dad sometimes. We have arguments, we have little spats, but I can't imagine, like, even my mother-in-law. I think my mother-in-law is a raging narcissist. We're no contact with her. I don't like her. I'm not a fan. However, as much as I don't like her, I still wouldn't sue her. Like, that just seems excessive and way out of bounds. Just
Yeah, I can't get over that bit. How can you sue your family member? I mean, like, okay, I mean, if it was, how can I put it? If it was, if it was a serious reason, then yeah, I could understand it. You know, stealing money or something like that. You know, or stealing a
Called
newborn.
me crazy. If I had a dime for every time my mother-in-law called me crazy or said I said something that I didn't, or, you know, whatever, we'd be not living in this house. We'd be living, you know, in the upper east side of freaking Manhattan in a high-rise apartment, living the high life, because I'd be richer than shit. Anyway.
I mean, it doesn't make any sense, does it?
It doesn't. And that's the thing. Like, y'all read my stuff, and my interactions with people aren't always appropriate. However, I still can't see myself doing that. Plaintiff alleges that she cannot seek any remedies with the Florida Supreme Court while her case is pending before the referee, and quotes an order from the Florida Supreme Court's docket requiring that she submit filings to the referee rather than the Florida Supreme Court during the stage of disciplinary proceedings in which these matters are pending with the referee. Plaintiff also alleges that the referee denied a motion for continuance as she requested declaratory relief regarding that order. Plaintiff furthermore alleges that she attempted to seek the Florida Bar assistance in stopping the distribution of attorney-client privileged information involving her cases that were being dispersed to courts, the legal community, and the public, and that the Florida Bar advised her that the Florida Bar Council is not authorized under the rules regulating the Florida Bar to seek an injunction of the type she requested.
Which is fair, yeah. If they're not authorized to do that, then they can't do that, can they? You can't make someone do something that they can't do.
Yeah.
And then use it as an excuse in a court document. That's an oxymoron right there.
Yeah. Sharon, and that's why we're going over his documents next, because he co-signed calling people felons. So he co-signed her defamation. So instead of saying maybe that's not a good idea, how about we don't call people, how about we don't defame people and risk being sued ourselves, since we already have a couple of lawsuits open for defamation, among other things.
Yeah, I've just seen a cow. Yeah.
Plaintiff also alleges,
down.
I know. She states that members of the Florida Bar have published discriminatory statements about her mental health in court pleadings and open court, and that the Florida Bar has not taken measures to stop them. Plaintiff's claims for relief are asserted in 4 counts. Count 1 requests this honorable court to deem Chapter 3 of the Rules of the Discipline unconstitutional and order the Florida Supreme Court to follow the recommendations of the McKay report given by the ABA. Oh, you can't that right there. You cannot force. You cannot force a state to. You cannot force a state to abide by something that they don't abide by. If their bar wants to adopt that McKay report and those rules, fine. However, you cannot force them to do it. It just does not work like that. As far as I checked last time, there was nothing updated from November. So, and I had checked, I think, Thursday. So, like I said, Orange County is the easiest county to check in the entire nation. So, and since that is not the only court case I am following in Orange County, I'm kind of on that website a lot. So, what they say they might be doing and what they've done are 2 different things. And that's not to say that they're lying, and it's just I don't go by what people are saying they're going to do, because I say a lot of things and people say a lot of things that never come to fruition. I go by what's in the court record.
And also, the bar has to be unbiased. They can't involve other courts. That's why the disciplinary bar or court system is separated from all the rest of the court system, so it's unbiased. So any disciplinary or any investigations are done by them alone. That's why you've got judges and solicitors on the fucking board.
Yeah, it's just one of those things of like when people. That's why I have that rule. Like I call it a petty chat rule, but it's kind of like a. I call it a petty chat rule, but it's not really a petty chat rule. It's just I don't really go by I heard from so and so or this person said on their stream. I go by what's in the documents, because a lot of the times what people say they're going to do is not what their lawyer ends up doing. There's a difference between what people want to do. And also, Megan and Tug, I love them, but they can be kind of clickbaity sometimes.
Yeah, a lot of people are.
A lot of people are. The way of YouTube.
I still need to learn that part.
People thought I was clickbaity one time when I said Megan gets sued, and I had a picture of Megan Farina, or Megan gets canceled, and I had a picture of Megan Farina. I was literally talking about Megan Farina from TikTok. Megan Farina gets canceled. Megan gets canceled. There was no clickbaity in it, but people still took it as clickbaity and thought I was talking about Megan Fox. And I was like, no, I literally have the picture of the Megan I'm talking about.
Yeah, that's funny.
I was like, yes, documents are receipt and proof, and that's why I go based on the documents and what's filed. Because a lot of times people are like, say this is what might be filed, this is what's going to be filed, this is what's going to be filed, but also it doesn't always happen that way. But we will I'm looking just to make sure.
I just find it very peculiar that she expects to treat the disciplinary board like any other court. You can't, because the thing is that it's not about plaintiff and defendant. You are on the fucking chopping block. You are the one who's being investigated. There's no plaintiff. There's no defendant. It is you.
The last thing that's on the record in Megan, Jeremy, Elephant Shoe, Martha, George, Risk, Megan and Tug versus Leslie and Michael Ferderigos was 11/9/2025, a notice of unavailability. Before that was 9/2/2025, a motion to dismiss the amended complaint, and that was 9/2, and we had read that. But also, those were that's the last thing that filed in this case. So what might be filed and what is filed, two different things.
Let me ask you a question on in regards to this. With all the cases, like, with all the false, the lawsuits and everything she has done towards, all the individuals, what would she do, or what would happen if those individuals turn around and says, right, that's defamation, slander, so I'm going to sue you for taking me to court on false pretense?
That would be interesting, but to this date, nobody's done that except for Megan and Tug and Jeremy and George, of course. When I say Jeremy, George I don't mean to like leave her out, but she's kind of implied that she's going along for the ride.
I mean, I'm not inciting anything, but I personally think that, I think it's about time that people who do have justice and the right to reciprocate.
Well, in looking at all of the lawsuits that she's filed, the only people to do that, turn around and sue her back, is Jeremy, George, Megan, and Tug.
Yep.
However, with that being said, with 2 open foreclosures, where does she get the money to sue people?
That's it. Yeah,
suing people takes. Yeah. So just suing someone took $420 on Randy's part. $420 just to sue and initiate.
How many? That's 4. So you times that by 4, right?
and you can times it by a lot. But
didn't she serve someone?
And Ninja Puppy, thanks for the $1.99 super chat, getting my crown back. And Jeff, in Florida, the bar doesn't hand down disciplinary or disbarment. Investigation is completed by the bar and board and sent to Florida Supreme Court for sanctions, discipline, or disbarment. So,
oh, there you go.
I think it's expensive, and she does a lot for free. I'm curious as to how she does it for free. It's just, but it's nice to read a filing in her cases that's coherent. I mean, it is technical, but it's coherent. Count 2 is declaratory judgment, direction on relief from the referee's order, denying plaintiff's continuance, clarification on whether the Florida bar can take measures to protect attorney-client privilege, information during their disciplinary investigations, specifically what measures the Florida bar can take to protect this confidential information. And I'm skipping over this because we read this in her complaint, because this is literally just quoting her complaint. So, count 3 requests injunctive relief under the ADA. Count 4 requests the same injunctive relief as count 3, but under the Florida Civil Rights Act. Here we go. Legal standards. When a complaint is challenged under the Federal Rules of Civil Procedure 12b-6. Don't do it. A court accepts as true all well-pleaded factual allegations and disregards unsupported conclusions of law. Ashcroft v. Iqbal. Where have we seen that before?
Mm-hmm.
Never seen that case before. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief as plausible on its face. A dismissal on sovereign immunity grounds should be pursuant to Rule 12b-1 because no subject matter jurisdiction exists. Argument. Immunity bars plaintiff's complaint. 11th Amendment immunity. 11th Amendment immunity makes clear the Florida bar is an arm of the Florida Supreme Court, is immune from plaintiff's claims. And we all know how I feel about immunity. It's in the rules. However, limited immunity does have a place. I saw the link you sent me. I didn't get to watch it because life, but you know. Can we go over the fees to sue? It's different in every jurisdiction, but literally when I was looking at the Orange County Clerk of Court, on the bottom of it, it has a financial section, and it has transaction assessment and payment on 7/28/2025. Randy Shockett paid $20, and on 7/21/2025, Randy Shockett paid $400. So far in this case, Jeremy has paid $420 to sue Lips. I don't know what exactly all that money is for, if it's for things specifically. However, it was a situation of you can see in the financial part of the docket report. It's right there. It doesn't break it down as to like what it, like a line by line receipt. But it does give you an insight into the cost.
One thing I can assure you of is that all this is costing fucking brain cells.
That is true. I'm learning a lot, but losing a lot at the same time.
Yep. I probably yeah.
11th Amendment prohibits actions against state courts and state bars. We previously held that the Florida bar is entitled to 11th Amendment immunity as an arm of the state, and the prior panel rule requires that we adhere to the holding. This immunity applies to both legal and equitable claims. Applying 11th Amendment immunity to suit against the Florida Supreme Court and stating that the district court lacked jurisdiction over the claim because sovereign immunity independently bars it. 11th Amendment sovereignty immunity prohibits federal courts from entertaining suits brought by citizens against a state, including its agencies and departments. That bar exists whether relief is sought is legal or equitable.
There you go. the fact that they have to explain that is just wow. You see what I mean about brain cells? I'm not even legally trained, and even I know that what you just read out was exactly what I meant. Stupid people.
Makes you wonder if people cheated in law school.
This is why they invented those bullets called dum-dums. Specifically create.
No, the further analysis is required with respect to application of 11th Amendment immunity to count 1, 2, and 4. With respect to count 3, on the other hand, which is asserted under ADA, Congress may validly abrogate sovereign immunity under Title II of the ADA for cases that allege an actual violation of the 14th Amendment. In this instance, however, 11th Amendment immunity also applies to any claim against the Florida bar in count 3 because there's no valid 14th Amendment claim alleged. Specifically, although it's unclear which defendant or both are intended to be named in count 3, the claim appears to be that members of the Florida bar, i.e. attorneys licensed to practice law pursuant to the rules regulating the Florida bar, have made discriminatory statements about plaintiff when the Florida bar and staff investigator had full knowledge and could have taken measures to stop it. The statements at issue appear to be alleged in paragraphs 48 and 49 and 50 of the complaint. Plaintiff alleged that the Florida bar continues to allow these type of statements to be made to the court systems of Florida about the plaintiff. Congress has abrogated 11th Amendment immunity where cases allege an actual violation of the 14th Amendment, or based on proper prophylactic legislation under 14th Amendment, which requires a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. The allegation that the Florida bar continues to allow these types of statements does not meet either requirement.
Can you take that comment down?
Oh, sorry.
Thank you.
Yep. The plaintiff does not have a right, including any right protected by the 14th Amendment, to require the Florida bar to take measures to stop the speech of others. Where does your First Amendment?
She really tried there, didn't she?
And even as a layperson, reading this is kind of like common sense and not hard to read. Yeah, they're using some big language in it, but like what they're saying is not hard to comprehend or understand, which is part of my my criticism of lawyers sometimes is they make shit so hard to understand for the common person. They overdo it to try to prove they're smarter than us. And it's like, whereas this is, it's basically like, no, this ain't working. Yeah.
Yeah, Cajun, I put your brain cell. Yeah.
It's starting to sound as if she's a sovereign citizen type of law, unless I'm hearing it wrong.
Yeah. And Cajun, I put your brain cell in a pot and it's on the shelf, so don't worry. It's safe. It is safe. I'm using it as an emergency just in case. This sounds to me that what she's trying to do, this is just me. This is just allegedly and speculation. I am in the belief that she's trying to emotionally blackmail the board and using excuses, but at the same time, she's trying to use the system to fight her fight. But then again, from the evidence that I've seen over the last year, since her involvement in all this, all I have seen is an absolute psychopath. An absolute nutter trying to intimidate and trying to sort of like push people in the corner by using labels and her own condition. If she knows that she's in that she has issues, why is she doing this in the first place? And at the same time, the court should be looking into this, because if this is not the first time that she's done this and then used labels, maybe someone in the legal profession should investigate this. Maybe there should be an investigation on her behavior and conduct and court cases she's been involved in, and that also involves her husband Michael. Because funny enough, where she is, he is, and where he is, she is. But here's a question for you, very quickly. If she was only a lawyer for 6 years, how come she endorsed him in 2002? Oh, 2005, sorry. Just saying. Carry on, as you were.
I'm not even going to touch this one with a 1,000-foot pole and some prophylactic antibiotics.
Yeah. Sorry. I Richie laughed out loud on that one. I mean, like reading this as a non-lawyer, to me, it looks like she's trying to entrap the system to have her way and using labels for it. Unless I'm wrong.
No, that's kind of where I'm kind of going with it. Like, at the same time, the allegation that the Florida bar continues to allow these type of statements does not meet either requirement. The plaintiff does not have a right, including any right protected by the 14th Amendment, to require the Florida bar to take measures to stop the speech of others.
Mm-hmm. Freedom of speech. It's not hate speech. If it's hate speech, then they could have done something about it. Or if it was threatening speech, they could have done something about it. But it's not. It's free speech. Just because you don't like what someone is saying doesn't mean it's criminal. But if the moment it becomes threatening or terroristic speech, then they can step in and do something about it. Like if someone calls you an asshole, grow a thicker skin. Sorry, but you guys go, you pipe up all the time about your First Amendment, and she does that as well. She pipes up about, ADA protected and everything else. Well, newsflash, sweetheart, sticks and stones may break your bones, but words can never hurt me. Simple.
It's one of the reasons that when people tell me they don't like me, I'm like, okay, there's like 10 million people in this fucking YouTube that maybe do. Here.
Do you know what? If people don't like me, but they still listen to me and they still watch me,
it's on the table.
Then it's nothing to do with disliking. It's nothing to do with the knowledge base or information base. It just means they don't like me. Fine, that's not a problem. It doesn't mean I'm going to change.
Not everybody is going to get along, and that's okay.
Exactly. I mean, look at yesterday. Squid fucking, did it again, and I growled. And I had to take a moment to pray to my 6,000 gods.
Yeah. Well, Spawn, if you read according to her, it's a federal felony, so her words are illegal to her. Words are...
Well, me and Squid are going to prison again because apparently we're felons. So therefore, we've already broken our probation and our what's it called? Our parole level. So that means we're going back to prison. I mean, her cell's a bit further down. She's in B and I'm in C because I'm a god. She isn't. So, that's why she's down one corridor and I'm a level higher. So. But this tells me that she's just trying to use.
Have fun.
Say what? What?
April's crocheting more just got here. I said, have fun.
Yeah, enjoy.
It's an interesting start, to say the least.
I'm surprised the courts don't. There must be a part of the courts, regardless of what court they are, when you know that someone is putting a frivolous claim in or making frivolous statements to try to enforce the claim or enforce the case. Why don't, I mean, like, you know, if they can do a psychological evaluation on paint chips, why can't they do it on her? Problem is, though, this was when she was still a lawyer. She's no longer a lawyer now. But they can still do one on her. And him.
I don't know. I got nothing.
Yeah, hey, Trump, instead of going for Greenland, why didn't you sort out your legal system? Sorry.
I got nothing. And no mentioning politics on my stream.
I know.
Well, we would do not time, not place.
I know. I did say sorry right afterwards.
However,
yeah,
we're gonna get into this part because it's in the Florida Bar v. Tyson. The court explained this court routinely receives inquiries from individuals who are unhappy with the bar's handling of their complaint against an attorney. Understandable. The role of the complaining witness in a bar disciplinary proceeding, however, is somewhat analogous to that of a victim in a criminal proceeding, and like crime victims, complaining witnesses cannot demand that the prosecuting authority file criminal charges against a particular individual based on alleged criminal behavior. Disciplinary proceedings against attorneys are instituted in the public interest and to preserve the purity of the courts. Not private rights, except those of accused attorneys, are involved. The Florida Bar may investigate a complaint or initiate an inquiry or not. Further inquiry into the motive behind the choice to investigate or bring disciplinary proceedings or not is not barred by absolute privilege and certainly not inconsistent with any established right. Nothing in the 14th Amendment suggests otherwise. Because 11th Amendment immunity applies to all of the counts, all claims against the Florida Bar must be dismissed for lack of subject matter jurisdiction. And hey, Joan. I mean, there's a lot of places that this could go. Absolute immunity, and we all know how I feel about immunity, but it does occasionally have a place. And telling a federal court how that it should regulate state bar and state Supreme Courts is not really where it's not their job. It's not their job. Absolute immunity, Florida Bar and its agents also have absolute immunity from civil liability for acts in the course of their official duties concerning attorney disciplinary proceedings. This absolute immunity arises from the fact that the Florida Bar and its staff counsel are agencies of the Supreme Court for the purpose of administering its jurisdiction. The Florida Bar is thus an arm and part of the judiciary. And although I hate judicial immunity, it does have it's like you can't sue someone for filing a complaint against you. Which is what she's essentially doing here. She's suing the people who were investigating her because she doesn't like that they're investigating her or how they're investigating her. It's not your plate. Like
the only time she can complain about the way they're investigating her if the investigations are overstepping their boundaries. You know, if the investigation is going into subjects which has no bearing on the case itself. You know, so it's none of their business if she walks around in bikini, you know, or it's none of their, you know, unless this is what I was saying earlier on, unless they bring in a psychological evaluation on her behavior, right? And then they say, well, she's walking around, you know, so there has to be a limit, right? Of the investigations. However, these investigations they're doing is based on her behavior in courts, not in her personal life. So why is she complaining? Because they have to do their job. To get a correct treatment, you have to allow them to investigate.
She doesn't like the fact that they're investigating.
There you go. What's she hiding then? Which then takes you back to
I wouldn't like if someone's investigating either. However, it's people's, like, it's the Florida bar's right to investigate you if you're in Florida and you're a member of the bar. Like,
Yeah. I mean, it's like, I mean, last year, I don't know, at some point someone turned around and said, oh, you know, I was investigating someone. There's no such thing as going onto Google, typing in a name or a location, and then doing research on said name or location. That's research. An investigation means I go digging into you.
Henry, I timed you out. That wasn't my mods. That was me. I asked Spawn not to bring up politics, and he apologized. So after I asked my guest not to bring up politics, when I asked my guest not to bring up politics, because this stream has nothing to do with politics. When we are talking about politics, you can bring up politics all you want. I don't care. But we are not talking politics. So I timed you out for 5 minutes. Sorry, but when I ask my guest, I'm kind of 2026 is like a zero tolerance policy for bullshit in my chat, because I dealt with so much crap, and so I was tolerant of so much BS that not a lot of other people are tolerant of. And then people would go, you get derailed. It's like, well, when I ask my guest not to talk about something, that kind of that's an implication for the chat not to talk about it too. Just a
yeah, my apologies, Henry. That's my fault. Again, you know, it was a slip of the tongue, but please do no politics, okay?
Well, if he would have done it before you, I would have warned him and then warned you. But I had already said, please don't talk about politics on this stream. And then he mentioned it after that while insulting me in the process.
Oh, well. Because
his comment was when the bubbas of the US. So that was me. So you not only, you know what? Fuck that shit. You called me a bubba. Fuck that shit. You're hidden from this channel. I reread your shit, and like you personally insulted me based on who I voted for. Sit on it and rotate. I don't do that to you. I don't insult anybody based on who they vote for. And you literally, you don't have to like who I voted for, but please don't insult me. And you literally just fucking insulted me.
Anyway, let's get back on topic. My humble apologies. It wasn't intended. It was just a slip of the tongue.
Yeah. You should know me by now. Thank you for exposing someone who would call me a name and not even give two fucks that they called me a name.
Wait, I did a what?
They said, Spawn, when the bubbas of the US elected demented narcissist idiot for president, you get epic levels of idiocy. Well, he just called me a bubba. He just called me a name. He tried to be derogatory towards me based on who I voted for. So,
okay,
thank you for exposing someone who doesn't have any problem with calling me names based on who I voted for. I don't want someone like that in my chat.
Well, all I can say is then just don't blame Jeremy, blame me.
So, I unhid you from this channel because I realized that I'm not like everybody else. So I unhid you from this channel, but please spare the insults based on who you vote for, because we don't do that shit on this channel. And if you decide to insult people based on who they vote for and call people names based solely on who they vote for, you are not welcome on this channel. Yes, what the fuck, people? Give politics a rest. Yes, personal insults will get you like on my shit show.
Yeah.
Like, and you see what happens when people get on the shitty side of my personality is they get content made about them for a year.
Because you're gonna go on about this for a year?
I'm gonna go on about her personal, her fucking like.
Oh, her, yeah.
Her trauma dumping she got on my bad side, and I'm gonna go on about her trauma dumping in documents until I run out of documents. Whether that's a week, 6 months, a year, but based on the amount of filings that she has, it's going to be a while.
I am going to enjoy that ride, that's for sure.
So,
because I've got my 5 cents I want to fucking make.
Well, like I said, I don't even even with her, I don't generally do personal insults.
There's a difference between personal insults and satire and humor.
Yes.
There's a big difference.
But when you just call me a name based on who I voted for, you can sit on it and rotate because no.
Yeah. I mean, I mean, that's where I think a lot of people are starting to lose the actual understanding of what satire and humor is when you're taking the piss. And you know where you have to like put satire and humor to one side and actually look at the seriousness of the topic at hand. You know, okay, I slipped up. I mentioned the P word. I apologize for that.
Yeah, and honestly, the political comment would have just gotten a short little timeout, but like,
yeah, I didn't see that myself.
But the personal, when I reread the comment and I saw the personal insult just based on who certain people, including myself, voted for, you basically insult me. Please.
Anyway, let's get back onto this.
If you want to know how I am when I get pissed off, please see the first 45 minutes of this stream.
Yeah.
I went after a creator that has 3.34 million subscribers and didn't give two flying fucks. So I have no qualms about telling someone what I think when they're hiding behind a keyboard.
No, it's not derailed. Now, here's one thing. Let me tell you right now. Okay, people think that like when I stream or when Squid streams, we get derailed very easy. No, we are very opinionated. We say it as it is, and we can easily go back onto topic like that. Right? It's the thing is, at the end of the day, we are human beings. We're not machines. And if we want to, you know, go off topic for 20 minutes or half an hour, then so be it. Because everyone who knows us and has got to know us, not just on a personal level, but actually know us, you know, like Squid and I know it we know each other very well. I know her whole family. So when she becomes like this, even I fucking I duck. Because at the end of the day, I know what's going on. Now, we may not be talking about this topic right now, but we can go straight into it like if we never left it. That's one thing, guys, you need to understand. We're not one of these people who are automated. We are human beings, and, you know, and this is not a dig at you. I'm just saying this is the way we are. And there's a lot of people who, you know, I mean, I know a lot of streamers, a lot of people who have their own platforms, okay, who come into my stream, my streams and her streams, and they are exactly the same, but they're off the topic.
So if you didn't think that I played well with others, please go back in the I read from my actual rating decision from the VA. And the VA says that due to my head injury, I don't play well with others.
No, she doesn't.
It literally says skull fracture due to your skull fracture. A severity level of 1 has been assigned for the social interaction facet, indicating that examiner has found evidence that social interaction is occasionally inappropriate.
I mean, what I find quite interesting is that like people are more interested in seeing emotional reactions. Now, I can tell you one thing: when Squid fucking goes off on one, that's not emotion. That's pure fucking fuck around and find out. And with all due respect,
you, I read it straight from the freaking thing. My social interaction is sometimes inappropriate, and that was back in 2009. This is my original rating decision in November 5th of 2009. So I was 23. And now I'm 40. So you can think if I wasn't appropriate in 2009, I'm sure it's appropriate.
I think like you know, the older you get, the wiser you get. But I tell you one thing: the more angry you get, and it's you know, I just
Devil Fan and I had like an hour-long conversation yesterday. And he has seen my completely like, I'm working with you one-on-one. You have my undivided attention in a professional manner. That is completely different than this.
Hang on a minute. So wait a minute. You talked to him for an hour and he didn't even fucking say good morning to me this morning? That's just bang out of order, that.
Well. He
It's like that
went
then.
on
Okay.
to Devil Fan. I'm going to use you as an example. He is not only helping me with figuring out the link tree and the booking stuff, but he is also helping me get back into one-on-one sessions.
Oh, okay. Got you. Right. Respect. Yeah. My apologies. I'll retract my comment.
So we are a team. But he's also helping me make sure that when you go in and you book a link, it's not confusing for people.
Right.
He's also helping me figure out the fact that Google Calendar and Linktree actually like works. So Devil Fan is important.
Devil Fan needs to understand his pecking order here, sunshine.
Devil Fan is very important.
Yeah, and it's misblasted to you.
All right. And hey, Cynthia. All right.
Back on top.
This complaint's allegations demonstrate any challenged actions of the Florida Bar were taken in the scope of the Florida Bar's duties. I agree with some of her complaint in the sense of like, I don't like what their actions are, but to me, that is part of being under investigation, and you're not going to like being investigated because
yeah, I mean, an investigation is not there to make you feel fucking jolly and happy and all that. An investigation digs into your fucking your digs in, and like at the end of the day, you like it or not, they have a job to do, and they have to stay unbiased, like it or not. If they find shit on you that like you didn't want them to find, you know, you should have mentioned it in the first place. Open, being honest is.
And now that I'm thinking about what. So we're on page 8 right now. We're going to go back to quote something that they had said, quoting her complaint. And I just, for some reason, I don't know why this didn't strike me earlier. But it said, she alleged, she alleges that that there's the derogatory claims against her, comments about her. Do you notice she says derogatory, not defamatory?
So that's a complete different argument then.
Well, she says derogatory, but she says derogatory and then talks about them as if they're defamatory. Not everything that someone says you're going to like. Yeah, like that comment that was made. All is forgiven. The person apologized. All is forgiven. I'm just going to use this as an example. Yeah. If we were out in a public setting, or he wants to put it on his Facebook, I can't stop him because that's his First Amendment right. I don't have to like it. Oof. However, it's his First Amendment right. So if someone wants to put on a fucking YouTube channel or something, or their Facebook or their Twitter or whatever, that I'm a horrible lawyer, which I'm not even a lawyer, so that would be like stupid. But you get my point. She uses the claim. She uses the claim of derogatory, but you notice she never says defamatory. This is where it's like, oh, because if she would have put defamatory, that would have given the Florida Bar a whole nother set of like things to fight her on.
Oh yeah.
And it was like, for some reason that just clicked.
And the thing is, it's day and night. Those two words.
Right here. The claims appear to be that members of the Florida Bar have made discriminatory statements about plaintiff. She says discriminatory, not defamatory. And not every statement that someone makes is going to be something that you like. But just because they say something about you that you don't like does not make it like the D word.
Yeah, it's a good bloody point.
I just, for some reason, after reading 2 complaints and this response or this motion to dismiss, that just clicked. I don't know, and I don't know why. Like,
No, it's a good point, because, like, at the end of the day, there's a big difference. With everyone calling people racist, there's a big difference between the word discrimination and racism. If you turn around to call someone discriminate, you're discriminating against that individual. Where racism is against a culture, or like a whole freaking culture. So people have used the word racist so much now that it's lost its intensity, it's lost its reasoning.
Even the word defamation has lost its freaking,
defamation, slander,
throwing it around so much.
Yeah.
Cynthia, for those of you who are just showing up, the first 45 minutes or 50 minutes, I'm going to cut down to a different stream because it is on a different topic, but it is something that I needed to address. I just didn't have the time to make a different thumbnail or record a video. But we kind of talk about and react to Matt Walsh's video where he compares being 100% VA disabled with Somali daycare fraud.
Oh, snap. I mean, the veterans over in the States have like an uphill freaking battle when it comes to the VA.
So this document that I keep referring to and picking up.
Hi, Papa Squid. How you doing, bud?
Is my actual initial rating decision. It's not my current one, but it's the only one that I have on paper. And I keep it in my filing cabinet so that it's always like there. But it is my rating decision from the VA, which goes into everything that they did and everything that they're rating and why and how. So it's a thing. So we talk about that. That is the first 50 minutes. I will be editing that. So for replay crew, the first 50 minutes of this video will be separate.
Mm-hmm.
Yeah, it's and Papa Squid is on his computer in my dining room. So, hey, Dad.
Yeah, oi, come and say hello, you git. If he's in
Hold
your
on
living room, I expect some freaking banter going on here right now. Get in here, boy.
So the Supreme Court enjoys absolute immunity from liability in connection with these functions. The immunity extends to all judicial acts, regardless of motivation or error. The little has one of her remote control cars in the other room, so he's trying to keep her under.
Oh, do you know what you should do? Get a camera, take a picture, all right, and then make her a driving license. Come on.
I will see what I can do.
And then get a fingerprint on the back of it, a thumbprint.
He doesn't want to talk to that cheeky, but they've already spoken. Spawn has literally spoken to every member of my family, including my daughter.
Yep.
We've had conversations in baby squid speak. I don't know. It was like a foreign language to me. I'm sure it made sense to the both of them, but I had no idea what the hell they were talking about.
Yep. We talked about inflation and rent. Yep.
And the fact that she lives for free. No.
I know the whole tentacle family, and I'm quite proud of it as well.
And he's had conversations with my mother too, without me there.
Mm-hmm.
So Spawn and I need a good one-on-one. Oh
Say
boy.
What?
Spawn.
Yeah, we do actually. Yeah, we do. Yeah, that'd be a nice conversation. But I'm still not going to show you my face because I'm too good looking for you.
Not according to your daughter.
Oh, snap.
You're the one who said it. I'm going to cut that and make that a short. You know that, right?
What's that? Oh, snap.
You talking about your daughter calling you ugly at 6 months old?
Yeah, but that, like, I mean, she was a baby, for crying out loud. She didn't know.
Babies are the most honest among us.
No. Oh, I swear to God, this means war.
And this is how Spawn and I talk to each other when we're not streaming.
Welsh and short. No.
Okay. To the extent that Each of the counts encompass any conduct by the Florida Bar that involves the Florida Bar's official duties. For example, count 1 asks this court to order the Florida Supreme Court to follow the recommendations of the McKay report given by the ABA based on plaintiff's contention that she has been harmed by the Florida Bar and or the Florida Supreme Court in disciplinary proceedings carried out pursuant to Chapter 3 of the rules regulating the Florida Bar. Similarly, count 2 seeks declaratory relief concerning the referee's order issued in disciplinary proceedings. Bad word in U.S. recovered only $20,000 in shipment from China in 2020. Fake driver's license, like Monopoly money. It would literally be the same quality as Monopoly money.
Exactly. Yeah, but I could just
stature speech. Oh shit!
Yeah, listen.
Oh my goodness.
Yeah, you know the tip gets cold when it hits the anyway. Yeah, no, but like, can you imagine getting stopped by the Rosas, the police, and the police walks up to the driver's side and the passenger side, and you put the window down, and then Baby Squid just hands over her driver's license to the
Could
cop.
you imagine being pulled over by Jeff?
Oh God, that'd be funny as hell.
That'd be fun.
That'd
Not
be
really,
funny
but
as hell.
I had a cop follow me home today, and I'm like, just don't pull me over. Like, I don't know what I did wrong, but like, just don't pull me over. It's like every time I see a game warden, I I clench a little, and I'm like, I am not doing anything. I'm not hunting. I'm not like, but I don't have any licenses to keep current right now. Like, I'm not hunting. I'm not doing anything wrong. Why are you worried every time you see a game warden truck?
Sometimes police will follow you to get to a location unnoticed. Sometimes they'll do that just to get closer to like an area where they have to be, to make it look like they're following you or they're about to stop you.
Well, I had a sheriff's deputy over here the other day, but that was.
I mean, over here, I would love the police to stop me. They'd be there for a while.
I live within a stone's throw from the sheriff's department, so I could throw a baseball and probably hit the.
I've got a question here. I've just noticed something.
Yep.
If you are, I mean, I'm not legally trained, so this is a question.
Well, I'm not either, so you know.
No, you're not, Marlon. You have to sit there and wait. Here's the thing: if you are put in front of the disciplinary board, right, and they're investigating you, why the hell are you fucking arguing with them? Doesn't that give them more reasons to dig deeper?
You would think. I mean, from a strictly common sense, and I do hold a national license. I do
No,
hold.
you're not allowed to swear. You know that. You just swore again, by the way.
And I hold a national certification with NBCOT. So I still have to do continuing eds. I still have to, do certain things. I still fall under certain things. If I were ever, like when you're working in a hospital and Joint Commission comes in, and you don't just sit there and chit chat and bullshit with them, because they are not those kind of people. Those are the kind of people that you say, yes, no, I don't know, but I will find out and get back to you.
Say what?
It's like talking to a cop. You say, yes, sir, no, sir, I don't know, and that's it. Can I go home? Like, yeah, but those are people that you don't just sit there and shoot the shit. No offense, Jeff, but like, I talk to you because you are retired. But even my friends that are cops, when they are acting in an official capacity, you say, yes, sir, no, sir, I don't know, can I go home? Like,
I mean, like
you don't offer up any information, because anything you say can and will be used against you. I can only imagine that anything you say to a disciplinary board or do or say or put on social media when you are under investigation will also be used against you in that investigation. I mean,
they have changed the Miranda rights in this country where basically you're entrapped into, you have to talk. But again, going back to this, what she's been saying here, Right? I find it quite interesting because she uses it in every single case she's in. She always plays the victim and says, "Why are you investigating this?" And then she uses case law from cases that, you know, someone must have made a mistake and the other side noticed that mistake and they won that case because one side had a mistake. Here, you are being investigated. It's just like if the cop arrests you, takes you to the police station, you get booked in, and then they do an investigation. That's exactly what's going on. You're being investigated for actions and behavior that have been reported to the bar.
Cynthia, 2 years was for my state license, 3 years was for federal. So, you know.
Can you imagine me becoming an American lawyer?
Ugh.
Wait, what do you mean? Ugh.
Mm.
Payments, Dr. Pepper, and hugs?
You know,
It's not a bad deal.
I don't know. But
Anyway, let's go.
Do you notice the things in here that the Florida bar is not doing? They are not using her mental health. They are not mentioning it.
Not once. I haven't seen it anyway.
They are not mentioning anything from Facebook. They are keeping it strictly to the law. And we are on page 9 of 17. And we're probably only going to make it an extra like 5 or 10 minutes because I got to go to work tonight again.
Younger abstination. What the fuck's that mean?
Thank you. Thank you, Devil Fan. I appreciate that. I try. So younger abstention. This is what I don't know what it is. I've never. The court should also dismiss the claims based on the doctrine of Younger v. Harris. Younger abstention requires federal courts not to interfere with ongoing state criminal proceedings if certain criteria are met. And it has been extended to ongoing state civil proceedings, including state bar disciplinary proceedings. Applying Younger abstention to dismiss a complaint challenging a bar disciplinary proceedings. Thus, when a plaintiff asks a federal court to enjoin or otherwise affect an ongoing state bar disciplinary proceeding, the federal court must abstain. I mean, that seems pretty like not interesting, but like common sense.
It does, but at the same time, it does sound like, you know, I mean, if you're this is what I can't understand. If you are in front of a disciplinary, it's just like when you and I, when we were serving, and we got put in front of our bosses, line managers, sergeant majors, or section commanders, and we got disciplined, right? You go in front, you get disciplined, you get aggied, or you get charged. They send you away, they investigate it. But the thing is, they don't charge you. Pardon my, sorry, I jumped the gun there. Right? They investigate, ask you questions, they send you out, they investigate it, and then they bring you back in once the investigation's done, and then they give you a choice. You can either have my punishment, or you can go in front of the CO or court martial. So you always had two different.
And here's where Jeff's comment relates to yours, but also relates to something with me. I said, absolutely, if ever approached by law enforcement for investigative purpose, never have loose lips. Friendly, yes, but never have loose lips.
Exactly.
Speaking of that, thank you, Jeff, for reminding me. All of these lips document reads are going into a playlist of their own called Loose Lips Sink Ships.
You know what you should have on that playlist at the beginning of every video? You should have the naval or the international sign of stress, SOS, and then you just hear boat sink. Because like these cases that she has been involved in, it's just absolutely mind-boggling that someone can argue something when you've actually caused the problem in the first place. If you put in for you sue your husband for divorce or whatever, and then retract it, who's to blame? You can't blame the husband. You can't blame the courts. It's you. Here, she's trying to argue with a disciplinary board. I mean, that's like a cop going up to his boss and saying, "Hey, I am now the boss, and you're not." That's how stupid it is. I mean, it's like someone trying to say, right, okay, the courts don't have any say here. What I say goes, and the courts is I'm just listening to them out due to favor.
It's just, this seems like it's basic. I couldn't help it when I was trying to think of like a funny or simple thing. I was like, name of a playlist. I was like, loose lips, and I was like, well, loose lips think ships, and I was like, that's why you don't trauma dump. Pro tip: don't trauma dump in legal filings, because somebody petty is gonna come along and make your trauma dumping public information.
Do you know what?
AKA me. This is what happens when you piss off the wrong person. This is why you don't go around and just pissing off people for the sake of pissing off people. This is why you don't accuse people of crimes when they didn't do shit. Intimidation, whatever. This is why you don't go on a stream and say so and so tried to intimidate me, but never show the text messages to prove that or so and so was making threats, but you never actually show the text messages that I was making threats. The text messages just simply say, I'm pissed, please no longer contact me. That is a threat to some people in this world. But when you literally, because that is also accusing someone of a crime, because making threats is a crime. So there are a few people in this world who have accused me of crime, not just Lips. However, Lips is just the easiest target because she's the lowest hanging fruit. And the other person who accused me of a crime, he's got his own issues to worry about right now that have nothing to do with me, which is kind of funny in itself. Karma has to come a knocking, and it wasn't from me.
Do you know what this here reminds me of? I don't even know why it just popped into my head. Do you know what this reminds me of?
What?
Grit. And grit stands for group, range, indication, type of fire. That's how freaking stupid this is.
Yeah. Well, so we're going to get through this younger abstention part, and then we're going to call it a day. So without going into the case law that they mention, all of the factors for younger abstention are met here. First, plaintiff's claims clearly involve ongoing disciplinary matters pending before the Florida Supreme Court. For example, complaint includes requests for direction on relief from the referee's order denying the plaintiff's continuance, which would plainly affect the ongoing state court proceedings. The Florida Supreme Court itself has indicated that an interlocutory review of a referee's orders is generally inappropriate, even by the Florida Supreme Court itself, since the referee lacks the power to either reach a final decision or to implement that decision. It would make much less sense for this court to engage in an interlocutory review of a procedural ruling by the referee. Second, the disciplinary meetings against the plaintiff implicate important state interests. In Middlesex, the Supreme Court applied Younger to a pending bar disciplinary proceedings because a state had extremely important interest in maintaining and assuring the professional conduct of the attorneys it licenses. I mean, that makes total sense. I mean, this is like that. Yes, we're stopping. Yes, we're kind of getting sidetracked and talking about other things, but everything in the Florida bar's motion to dismiss is making common sense without having to be a lawyer to understand the legalese. They're writing it in a very clear. They're writing it in a very clear way, unbiased way. While not attacking her mental health or going after the fact that she brings up claims that have nothing to do with anything legally. They are not going after the fact that she trauma dumped. 10 pages in, and they are still just citing law. They are literally going after the law, not her personally, which is how legal filings should be. They should not be personal attacks.
Which now takes me back to the original thing I said earlier on, that people that she has attacked and sued and then used her ADA or her labels, they can now technically turn around and go, right, we're suing you, and here's the pattern of behavior. Because this here richly opens her up, pardon the expression, which she opens her up for lawsuit.
She's basically asking for a manager. to come in and fire the bar. And no, Karen, it's not how it works. You can't ask for a Yelp review in the middle of a fucking procedure.
Yeah, that's so fucking. She can't ask Michael because he's only got one review, and that's fucking bad.
Steve.
Sorry. Being a shit mate, her mouth is an awesome flotation. I'd be saying that for life jacket lips. That's why I call her life jacket lips, Steve. Yeah, perfect flotation device.
I call her loose lips because she never shuts the hell up.
Yeah, that's giving her that's a compliment towards her.
No, it's not. Sometimes you need to keep your mouth shut, and she can't.
I got a new nickname for her. As of today, she is known as Womblegob.
See, and I would have never called her nicknames if she wouldn't have tried to call me a felon.
Well, she called me a felon, so therefore I'm going to call her Womblegob.
Exactly. You accuse me of a crime. I really don't give a shit about anything about you now. Like I said, I've got content till 2027. Thank you.
Yeah, yeah, that's it. Congratulations, Leslie. You are now known as Womblegob because you can't keep your mouth shut. Yeah. What you should do is go up to an infantry and ask them what grit or clap stands for. Then maybe you'll learn how to keep your mouth shut when you're supposed to keep it shut. And then,
So they mention a bunch of more case law, and I'm kind of skipping ahead here, but other than conclusory allegations, plaintiff does not explain why this process, including direct review by the Florida Supreme Court, is insufficient. Moreover, if the ability to raise constitutional issues in the Florida Supreme Court were unclear, which it is not, any doubt on this score would properly resolve in favor of abstention. More case law, because, the state actually does that.
Why is the bar against Welch? What we do? We didn't do anything. What the fuck?
Plaintiff fails to state a claim on which relief can be granted. In addition to the immunity and abstention issues above, complaint should be dismissed because it does not state a claim. Count 1 asks this court to order the Florida Supreme Court to rewrite Chapter 3 of the rules regulating the Florida bar. It's unclear if the Florida bar is intended to be named in this count, but in any event, the Florida bar does not issue and approve the rules regulating the Florida bar. It does not carry out disciplinary procedures pursuant to Chapter 3's procedures. The basis for challenge is plaintiff's disagreement with the aspects of Chapter 3 and her allegation that the rule has resulted in unfair outcome due to the procedures afforded her. On its face, however, Chapter 3 is replete with due process, including the right to be heard by the referee and the Florida Supreme Court at the appropriate times prescribed in the rules. She acts like they're just doing this to her. Like, this chapter goes to everybody. Chapter 3 is everybody who ever gets a bar complaint. Like, she acts like it's personal to her.
Yeah, and also she should know the rules as well, because being a lawyer, she should know the ADA rules of professional conduct. So this shouldn't be a surprise for her. This shouldn't be anything new for her. She should know the rules, professional rules.
Plaintiffs argue that the right of every litigant to appear before an impartial tribunal is a fundamental tenet of the constitutional guarantee of due process, but she is not being denied that right here. Florida Supreme Court is clearly an impartial tribunal. The Florida Supreme Court also has repeatedly explained how procedures afford respondents under Chapter 3 the right to satisfy due process requirements. Case law, the U.S. Supreme Court has similarly held that where an attorney was put on notice of disciplinary charges against him and was afforded the opportunity to respond to a recommendation of discipline, the demands of due process were satisfied. Plaintiff's allegations that Chapter 3 is unconstitutional, whether because of local investigative committees or otherwise, is unfounded. Count 2 asks for declarations under the Declaratory Judgment Act. On 3 questions, it would require this court to exercise oversight over a pending state court. Declaratory Judgment Act provides, in pertinent part, in a case actual controversy which in its jurisdiction, any court of the U.S. may declare the rights and other legal relations in any interested party seeking such declaration, 28 U.S. Code 2201. For purposes of the Declaratory Judgment Act, a case or controversy exists when the facts alleged under all the circumstances show that there is substantial controversy between parties having adverse legal interests of sufficient immediacy and reality to warrant the issuance of declaratory judgment. More case law. Plaintiff provides no further details for why she needs declaration regarding the referee's order denying the plaintiff's continuance. I mean, the lack of any allegations regarding why such a declaration is needed further illustrates why dismissal is required. Because she trauma dumped. She didn't actually clearly state her cause of action. She just trauma dumped.
And something else I've noticed, this document, I think this document was the catalyst of her quitting.
Possibly.
Because the thing is, like, you can tell that they were not backing down and they were just coming back with case law. And at the end of the day, they have a job to do. They were doing it by the book, by the rules. They were not overstepping. And I think this is probably where she was like going, yeah, I'm not going to win this one.
And guess what? We all have, everybody in this country, there is laws in this country that we do not like. But the thing that I think that I hate about people in this country is that people just bitch that they hate the fucking laws and they hate the fucking rules, but they don't actually talk to anybody or petition anybody who has the job of changing the fucking laws to do anything about it.
Yeah, but they also
don't enforce it or try to get the law enforcement or the bar or lawyers to not enforce it.
And the thing is,
instead of just going to your Congress or your state legislatures and getting them to change the mother freaking laws.
And there's also, the thing is, a lot of people seem to forget that there are laws and stipulations in your constitution and in your laws that actually protect you and support you. And the thing is, a lot of people don't realize that. They just see the negative. They just see the bad guy. And just because you've got the DA or you got someone on the other side of the room fucking pointing a finger at you and making accusations, don't forget, you've also have protection within the law. The law, that's why the lady with the weighing machine is blindfolded or whatever. Justice, the lady of justice, right?
Scales of justice are blind.
Blind. So therefore, you should have exactly the same right as everyone else on in that country to have the protection through law. And this is the perfect example. You can play the victim as much as you like, but in the law it states bang, 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 bang. There you go. Yeah.
This document is just a small example of why she had so many bar complaints.
Yeah. And someone said that this is, she's a professional victim. Absolutely. And she's not the only one. Other people from the from that group have played the victim and used case law, to try to either intimidate, threaten, or overwhelm someone. But what they don't realize is that, like, their actions speak louder than their words. And that's why it's all backfiring on them. That's why the Titanic 2.0 is, oh God, this woman is so stupid. I tell you.
Well, the thing about it is, like, counts 3 and 4, the last part, asks this court to enjoin speech by parties other than the defendants, the Florida Bar and the Florida Supreme Court. The complaint does not explain how these defendants would be governed by such an order. If the requested relief is intended to require the Florida Bar to take measures to stop such speech, plaintiff has no such right to obtain such relief. Moreover, to the extent that count 4 is not dismissed for the reasons above, the court should decline to exercise supplemental jurisdiction on the state law question. In short, there is no well-pleaded claim against the Florida Bar unless relief can be granted. You could see, compared to her first motion or her first complaint, the farther we got into it, the speech started to change. She went from first person to third person, back to first person to third person, sometimes in the same paragraph, sometimes in the same sentence. You could tell that she was very emotional when writing this. This wasn't the level-headed, and that's not legal analysis. That is, I am not a psychologist, but I have enough of a psychology education to tell when someone is emotional writing versus, I've taken writing classes, business, creative writing, college courses, the fun prerequisites, business writing, whatever. And then I've taken psychology classes, and you can tell when someone's writing goes from being professional at the beginning of a document to overly emotional at the end, because their sentence structure changes, their tense changes, the way they use everything just changes, and you can see that they're getting angry and angrier. But then she added, in the amended complaints, she added all of the Facebook stuff and the names, and she got extra personal. We are on page 15. We got to the conclusion. Not once did they ever get personal in their response. Never once did they bring up her mental health. Never once did they bring up her Facebook posts. Nothing. This is the difference between a lawyer who is doing their job and a lawyer who is out for revenge. From a medical background perspective, and someone who just has a background in legal writing, or not legal writing, medical writing, but who also has a background of working with people who get agitated, and you can see the way their mind changes when they go from a normal state to I hate everything and everybody state. You can just see the switch. This is also why you don't trauma dump. You should not write. This is in my opinion, this is a lesson for life. She did this in a legal filing. However, when you are writing text messages, when you are writing letters to landlords, you are writing affidavits for police, anything. If you are overly emotional, stop writing. Take a break, get a drink of water, take a walk, come back when you are not emotional. Because when you are overly emotional, things never go right.
Yeah,
ever.
And she can't dance for shit. I've seen people being tased who can dance better than her. Sorry. What?
So they basically say, because the Florida bar is immune, abstention is appropriate, and plaintiffs failed to state a claim, the court should dismiss the claims with prejudice. I'm curious, can they bring up her mental health? I'm sure they could. However, because we know from her interactions with Megan, Tug, Jeremy, anybody on the internet, just Jay.
See you later, Stephen. Bye.
She likes playing the victim.
Yeah.
I believe, this being 3 years ago now, that the Florida bar knew this, had seen it. She liked to play the victim. It was probably in some of the bar complaints that she was emotional. So they didn't, because they might have had an insight that if we do this, she's going to use it against us later.
But I think
this is just my thought process on what I would do if I was them. They kept it strictly.
Yeah.
They didn't argue her feelings. She argued with feelings. They didn't argue feelings. They argued fact.
And law.
And law. Yes, they argued fact and law. And when you do that, in my opinion, I'm not a judge, not a lawyer, not a judge, but in my opinion, your shit comes across a lot more on the rails, a lot easier to read, a lot clearer, a lot more sane. When someone, it's just in an argument, when someone gets emotional and they start name calling and this and that and calling everybody a Yahtzee and this and every name under the book, you've lost the plot. I can no longer have a conversation with you because you're name calling. I'm name calling her because she called me a felon, or she accused me of a felony, which is defamation. So my ability to give a shit what she thinks and be civil with her kind of went out the fucking window.
I mean, there's a difference between name calling and using a bit of humor and satire jokes. Like when I call people knobsticles or cockwommels, You know, it's
I
more of a
call you a twat.
yeah, because no, it's a twat. It's twat, not twat. Twat. You know, and it's like if I really wanted to get serious with someone, trust me, by the time I'm done, their back teeth will be rattling. But I like to keep it humorous. I like to keep it like a, you know, but with her, the fact that she uses labels and her personal labels, like a lot of people do.
Whoop, hold on. There you go.
Really?
Sorry, when I changed the background, it doesn't have you added because you weren't here from the beginning. So
Consider yourself grounded. Anyway, because a lot of people seem to like to be experts, subject experts when it comes to mental health. No one, unless you are a professionally qualified psychologist or psychiatrist, you can talk about your experiences, but that does not make you a professional in that subject. And when you start using your condition you weaponize your condition, that's where you start losing face, because at the end of the day, it's no one else's fault or problem because of your situation. Now, if you bring in someone like a subject expert, like a psychiatrist or someone like that, then people can actually understand what's going on. Now, I do know that courts can request a forensic, it's called a forensic psychological evaluation for courts it's basically one of the stepping stones for making sure that people are sane to attend court. What was that? What did I just miss there?
It was nice seeing you, Squid, and just having Spawn in the background.
Oh, shut up. Anyway, but
final,
yeah, I just
thought,
think,
Spawn.
right, okay, ladies first.
You can tell that they did not argue facts or emotion. They didn't match her energy. They didn't match the petty or the high emotional state. They didn't match the bull crap, basically. They kept it facts only. They said what they wanted to do. They didn't add personal attacks. They didn't do what she did. And it made it an easier read. It was half the size. The writing stayed consistent from beginning to end. Yes, I didn't read the case law, and yes, we kind of skipped through some of it because we needed to get through it. And, you know, we're not reading every single one of these documents word for word like we do with new documents. However, we didn't want to make this we didn't want to drag this out because we're being entertainment and we're making sure everybody knows the history of her legal past and what she doesn't want everybody to know. And the Streisand effect happened. When you try to accuse people of crimes for reading publicly available documents where you trauma dumped, that's going to make more people look and more people interested. And also, do not try to intimidate someone who is pettier than you. I will win that petty argument every time because, as you can see, the VA told you my interactions aren't always appropriate. And that was back in 2009 when I had a filter. I'm 40 years old now. I've had brain surgery since then. I've lost my filter. I don't have one. It's a public document, and it's not my fault that you put your personal life and your dirty laundry in a public document, and now everybody gets to see your shit stains. Maybe you should wipe better and not shit in a public document, and nobody will see your racing stripes. Pro tip.
My turn?
Yep.
I was watching you. Right. Well, first things first. Injecting yourself into something that has got no bearing or anything to do with you is the first sign. The second thing is when you surround yourself with people who are from cut from the same type of wood, like Mr. Magoo, Skeletor, right, and other people like that, like with Bruce Matsky and stuff like that, right? You're making yourself a public figure and one with a spotlight on you. Now, with all these court cases and the way you behave, the way you conduct yourself, and the fact that you sat on the platform or the crampons and actually told everyone about your physical and psychological background, and then you want to attack people and you want to be taken serious, the fact that you weaponize your condition, you weaponize the courts, you weaponize the law to get your way. Well, newsflash, people can look through you like they're looking through a window. Me personally, I just think that, like, I mean, laughing about it, yes, you can have a little bit of a giggle. But when you accuse people of being felons, and when your husband, 1 minute you're divorcing him, the next minute you're sitting on a platform making accusations and calling people felons. And then you fucked with the wrong person. And as you can now see, the repercussions are on their way. And I don't think she started. I think Squid is just warming up. Now, when you do accuse people of stuff, especially online, it's there for good. It's there for good. And the fact that you've made multiple threats, the fact that you've actually you've actually slipped up on certain comments that you've made in your live streams, for example, how long you've been married, how long you've been together, all right, that makes people go, right, okay. And then if they've only been together for 14 years, but married 13 years, yeah. Okay, so the more you open your mouth, the more you're giving people the actual insight of who you really are. And by the way, please don't dance on camera again.
Me? Oh, her?
No, not you. I'm talking about lips. Like, please, for the sake of humanity, for the sake of the sanity of humans, please do not dance on camera again. Okay, because but there's an old saying. I used to get told. Well, I used to be told by my old man. He said, when you make your bed and you piss in it, it's your responsibility. So, Leslie, you lay in your bed because you've made it. Good luck. Because I'll tell you one thing. You're just like Richard Luthman. You're absolute spank stain. There you go.
All right. I have us set up to redirect to the alternate juror. She's doing Florida versus Dahlia DiPolito. Law enforcement testimony part 8. She doesn't start till 6 o'clock. However, go over there and give her a like. And if you love trials and love watching trials, alternate juror is your girl. Oh my God, she's awesome. She is so nice. I say girl, she's a woman. She's older than me. She's amazing, but she's gorgeous. So go over there, give her a like, tell her I said hi, and y'all have a great rest of your day. Spawn, do you want to yeet us out of here? Because I got to go work.
I will most absolutely politely yeet us. Ladies and gentlemen, mesdames and messieurs, meine Damen und Herren, Habibi, Habibti, 3, 2, 1, lolly.